You get this bill from an insurance company for $26,523. How is that broken down? Oh, we can't tell you what medical tests they had because that would violate HIPAA. Hi, Jeff Mersanti, the Plain English Attorney, and welcome to the video. Today we're getting back to basics with the 5 things that you need in every good power of attorney. Now, we are talking about a financial power of attorney versus a healthcare power of attorney. That's probably going to be another video that we'll do pretty soon, is on the healthcare power of attorney and what needs to be in it. But we're talking about, quote, the financial power of attorney. Now, it's important to note that when we're talking about this is a durable general power of attorney is the one we typically use, but there are all of these other names that are out there. And honestly, I think it's just so that attorneys can confuse you as to what they're talking about. There's a durable general power of attorney, a springing power of attorney, and a turtle dove power of attorney, whatever. They just come up with all of these different names. Look, all it really means is what does it cover? When is it active? And they come up with a different name for it. But really, all it's doing is it's taking care of, quote, financial and legal aspects, as opposed to the healthcare power of attorney that handles all of those things. If you think it's important for educational videos like this to get out there, then please help us out by subscribing to the channel. So the very first thing that you need in a good power of attorney, you need agents. You need to name someone who's going to be taking on the role and the duties and the powers that are listed out in the power of attorney. But this is a very important thing. You don't want just one person and cut it off there. If you do that, then there is absolutely no backup. So what is very typical for my clients, if it's a couple, they're naming each other, but then we're going into a list of 3 people. So the type of person that you want to be your agent, it's a person you trust their judgment, they've got a good head on their shoulders, they're kind of aligned with the way you would spend money and handle bills, or maybe they're even better at it than you. But the point is that you're going to trust them to handle things. They do not need to be attorneys or financial advisors or accountants. The main thing is that you've got to trust them and trust their judgment, because they can always hire, if they need to, an attorney or an accountant or a financial advisor to handle the details in those aspects. And you may already be working with those professionals. They can step in and help manage it. The idea behind a power of attorney is if you're not able to handle these things, that they can step in and do it for you for however long that may be. Now, that's the first thing. So what are we typically looking for? One person. If they can't do it, you've got a backup. And then if they can't do it, there's a third. So typically for couples, I really end up pressing them a little bit when we're doing our strategy session and going through and picking out the names. They've got each other first, but then 3 more. Well, why that many? Well, because I have been doing this for decades. And I have clients that come back to us, they revise their lists, but sometimes they don't come back to me for several years. If they haven't named 3 people, or if they do name 3 people, maybe 1 or 2 people are either no longer here or they're not in the country. And it's like, wait a minute, we've only got 1 person there. Thankfully, knock on wood, we haven't gone through the whole list. The only time we have is when people refuse to put a 3rd person, or God forbid, they only go with 1 person and there's no backup. So you don't want to have that happen. So that's the first thing. Second thing that's in every good power of attorney, when it is active. Now, I already mentioned there's that durable general springing power of attorney. A lot of people are assuming that, okay, there's a power of attorney. It's only active when I am incapacitated. And it can be put together that way. But I got to go back about 10 years, maybe even more. There was this big debate with within the North Carolina State Bar. And got to blame banks and financial institutions for this one. This one is all on them. If you're going to put that the power of attorney isn't active until you're incapacitated, then you have to have a definition of what is incapacitated. And the simple one that was in most powers of attorney, these springing powers of attorney, that two physicians have certified in writing that you are no longer able to handle your own affairs. Well, apparently that wasn't good enough for a lot of these financial institutions, and suddenly they had to have a 5-page form generated that they need a doctor to fill out. Okay, doctors are busy. They've got a ton of things to do. It's like, my mom, she's incapacitated. You've seen it. Can you please just write this note? That's okay. Such and such a person did. They're incapacitated. They type it up. It's 2-3 lines. Sign it. Done. Now there's all these long forms. It's like, well, the doctors are like, okay, I'll get to this later. I'll get to this later. I'll get to this later. Suddenly it's a week and a half later. They've had all these emergencies. Doc, can you get me this? So it just delayed everything to the point where it got to be so frustrating that a lot of attorneys debated this and said, look, what should we do? We're going to just make them active now. Well, I don't know if I want them to have that power of attorney active now. Well, okay. If that question is coming up in your mind, I don't know if I trust them to have this power of attorney be active now. Well, then that's more of a, that's more on your end of maybe you don't have the right people in place. The thing is, if you trust them to handle these financial things and take care of you and not steal your money while you're incapacitated, then you should be able to trust them to not steal your money while you're okay and watching. So think about that. So generally, when is it active? Look, you could do whatever you want. The default is we're going to make that first person active now. And in all the years of my practice, I haven't seen anybody take advantage of that. I have seen people, not necessarily my clients, but in other cases, take advantage of a power of attorney after somebody became incapacitated. But I've never seen any of my clients' family members take advantage of them while they were fine. All right, so that's the second thing. What is the third big thing? You need to have the detailed powers all spelled out in that power of attorney. Now, this is something that just creates way more problems than it needs to. North Carolina and probably a bunch of other states, they have we just call it the short form power of attorney and the long form power of attorney. Well, what's the short form power of attorney? It says, okay, I'm leaving this person as being my power of attorney, and they're going to have the following powers. And then there's just 2-3 word descriptions of the powers listed and a little line where they can initial. You can download these forms for free. They're everywhere. But there are a ton of financial institutions that will look at that and go, well, that's not detailed enough. And I can tell you specifically in North Carolina, this is a big thing. There are a ton of court cases out there that say, well, if it doesn't specifically say that they can do this, then they can't do this. And so you end up with that short form power of attorney and like, well, this isn't good enough. Okay, we're going to take you to court. Okay, but look, the second you go to court, you've lost. Not that you lost the case, but you're losing because now you're having to spend money to go to court on a power of attorney to make sure that you can do these financial things. You're already wasting resources. So the best thing is to make sure that you have that full long-form power of attorney that spells everything out. Now, there is a long-form power of attorney that most attorneys in North Carolina will have access to, whether they choose to use it or not. That's based on their practice and their experience. We have that long-form power of attorney, and we have added to it over the years so that it spells out exactly what powers that they're going to have. And generally speaking, you want to make sure that they have as much power and authority to do what they need to do to take care of you. So if you're sitting and saying, well, I want them to do this, but I don't know if I want them to do that. Maybe they should be allowed to do this, but okay, we're going to cut that out. And so if there's a place in most of these power of attorneys where you can put in any limitations, if you're going to put in a whole bunch of limitations, it again brings up that same question. Do you trust them enough to give them that power of authority to do what they need to do? And if you find yourself questioning, oh, maybe I don't want to, it's about the choice of the person, not the document. So, fourth big thing that you need to have in every good power of attorney, and this is a big one, it's the ability to make gifts. And when I have some clients, they go, whoa, wait a minute. Do I really want to be incapacitated and have my power of attorney giving out gifts? Yeah, if the problem is you're incapacitated for something like Alzheimer's and dementia, and quote, gifting within a Medicaid planning context can get you qualified, yeah, you want to have that authority for your power of attorney to make gifts. Now, this absolutely drives me crazy because I look at the whole big picture. The default that I typically see in these power of attorneys, even the long form power of attorneys, when it's the power to make gifts, they're restricting the level of gifts to what is the gift tax limit in each year. So it's 2024. The gift tax limit is $18,000 gifts per person. And like, well, that's it. We're going to cut it off at $18,000. All right. That's if you're incapacitated and you want your power of attorney to make gifts to make sure you don't have a taxable estate. Oh, that's pretty standard in a power of attorney, but not Medicaid. So we actually kind of do both. We put that it's up to that gift tax limit, but there's this huge exception that you can exceed whatever that limit is if the purpose is for planning for public benefits, like such as Medicaid. And now they're allowed to shift money around and gift money in order to make sure that you can end up qualifying for Medicaid if it's done the right way. So let me just give you a statistic here. How many taxable estates do you think there are at the federal level? 8 in 10,000. So that's, what's that, 0.008% of the population will have a taxable estate. How many people are going to need long-term care? 1 in 3. That's 33.33% are going to need long-term care. So what do you think? Is it more important to have these limits for tax giveaways or for the purpose of planning for Medicaid? So that's an extremely important power to make sure that you've got in that power of attorney. All right, and now the fifth one. This is big because it can end up being, if you really are dealing with, in particular, a hospital or an insurance company that is very meticulous, it's HIPAA waivers. HIPAA is about medical information privacy. So if you want to look at the actual letter of the law, if you're the financial power of attorney, it's your responsibility to pay the bills for the person that you're the power of attorney for. You get this bill from an insurance company for $26,523. Well, okay, but how is that broken down? Oh, we can't tell you what medical tests they had because that would violate HIPAA. Okay, so now I want to make it very clear because some attorneys do this a little bit differently. I actually put these HIPAA waivers into that durable general power of attorney, the financial power of attorney. So it's right in there directly. It's in that one document. So if you're presenting that document as the power of attorney, the waiver language is already inside there. It's the same language in the healthcare power of attorney. Some attorneys do a separate form. Oh, we're going to do a separate HIPAA waiver. Well, now, whether it's healthcare or medical, you've got that waiver. You have to submit 2 documents either way. I just put that language and draft it directly into the document just a different way of doing it, probably a little bit easier, so that you don't have this extra document. It's like, okay, there's an emergency that, they're rushing you to the hospital. And now suddenly you're the person who's the power of attorney. You're going to have to pay whatever bills there are. Oh, we left the HIPAA waiver with the binder or with the rest of the documents. No, it's right in there. So those are the 5 big elements and items that you need to have in every good power of attorney. If you can think of any other things, please go ahead and put it into the comments below. If we get enough of them, we'll do a part 2 and add the good ones that you put in. All right. So as I always tell my clients, please stay safe, plan ahead, and enjoy life. And whatever you do, make it a great day.